Acquiring a particular software program or SaaS product is often the driving force behind a merger or asset purchase agreement. The seller has developed new, cutting-edge software, and the buyer, rather than develop its own product, wants to acquire a finished product that is ready or near ready to deploy. These can be win-win transactions, but the buyer must be careful in its due diligence about the state of the software and what it can do. Here are a few steps the buyer can take to avoid unwanted surprises. First, ensure that the asset purchase or merger agreement adequately describes the product. The software may be identified by its name, but it is recommended that there be a thorough description of the software's features either in the agreement itself or in a document that is incorporated into the description. That way, the buyer has a stronger legal claim if the software does not possess the features it expected. The description can also reflect features that are still in development or beta stage to ensure that the buyer acquires the rights to them as well. The buyer should consider hiring a software consultant to independently test the software. This would be done with the cooperation of the seller, who will likely insist that the consultant sign a non-disclosure agreement. The consultant's role is to test the software's performance against the description, check for major bugs, and inspect the quality of the source code documentation. This step can inform the buyer of the software's readiness and performance from the perspective of an independent third party prior to closing. Finally, the buyer should learn whether the software source code and any graphic elements are registered with the U.S. Copyright Office. If they are, the registrations should be transferred to the buyer in the agreement. Software can also be protected by patent law if it is novel, trade secret law if the seller has taken reasonable steps to keep it confidential, and the name of the software may be protected by a trademark application or registration. Conducting due diligence on these and other intellectual property rights can help ensure that they are transferred to the buyer at closing. Learning as much as you can about the software prior to closing is important for the buyer. Taking these steps will avoid unwanted surprises and contribute toward a win-win transaction.